Welcome to the Bedrock Way Podcast, where we're changing the habits of yesterday by creating the new healthcare reality of tomorrow. And Jonathan, do we have a treat for the listeners and the audience today? And it's rare the time that I get experts on my podcast, because I always say it's tough in life to be experts at anything because we're always learning, right? We're always students of every industry. But today, I do have experts, and I have legal experts, because I felt the need and compelled to discuss the recent FTC ruling, which will have a massive tectonic shift in relation to the non-compete landscape. And today with me, I have Richard Friedman and Raymond Baldino, two expert labor law attorneys who will introduce themselves and tell our listeners, our audience, all they do, but their phones must be ringing off the hook. Both employees and employers are reaching out to Rich and Ray and say, what do we need to do? What do we need to prepare? And there's one side of the coin that is saying, you know what, this FTC ruling is unconstitutional. They have no jurisdiction over levying such a law because they're part of the executive branch. There's the other school that says this doesn't have to stick because the aspect of non-competes is flawed or might be flawed, and maybe this is a law that is way overdue. And while companies in business need to have the ability to protect intellectual property, trade secrets, secret sauce, in a free capitalism environment such as the United States, employees should have the ability to go and get employment anywhere, especially healthcare employees that are licensed and trained to do things at a higher level. In a world where the socioeconomic environment continues to get more expensive, in a world where inflation continues to increase, in a world where the cost of doing business, and in a world where the toxic work cultures are being protected by non-competes and restricted covenants, I felt, gentlemen, this is the perfect time to have this discussion, educate our audience, educate our listeners, and get it straight from the horse's mouth. Two thoroughbreds that have succeeded in the labor law space in this area, seasoned litigators, seasoned experts. It is my pleasure to introduce Richard Friedman, Raymond Baldino from the Zazzali law firm to the Bedrock Way Podcast. Good afternoon, gentlemen.
Good afternoon, and thank you.
I'm excited. Are you guys excited?
We're ready.
I love it. Rich, we'll start with you. Tell our audience your background, how you got into this field, and why you love it so much.
Sure. My name is Richard Friedman. I went to Northeastern University, which has become even better since I went there, I think. Seriously, it's become a very good school. It was good then, but it's become very good. So, and I went to law school at the University of Tennessee in Knoxville, which is also a very good school.
I love
actually.
Tennessee.
And graduated a long time ago, and I've been doing this, let's just say I've been doing this for over 40 years, and I've been doing almost exclusively labor and employment, both for unions, for union members, for local education and other associations, and individual employee cases. In New Jersey, by the way, has had not restrictive covenants, although in a way these are restrictive covenants, but in a way New Jersey has had these provisions for a long time, although they've gradually gotten narrower. And I know that's true in other states. For example, Massachusetts, a few years ago, I know from personal involvement, passed a very strict, I believe limiting them to 1 year. Anyway, to make a long story short, I've done all kinds of cases. I started in labor and employment, 79, 1980, and doing all sorts of cases. And from time to time, the restrictive covenants would come up. And interestingly, the last two that I saw, one was a nurse, high-ranking nurse at a pretty large and well-known hospital in New Jersey. Another one was a pretty well-known advertising company. And the big thing about them, what we found is, at best, they were ambiguous, which meant it really wasn't clear when they applied, and it wasn't really clear what they applied to, but they were either clear enough, or I should say unclear enough, that it was hard to tell people they could just violate them at their own peril. And so they were pretty aggressive documents. And as an antidote to that, the commission has taken a pretty expansive and a pretty broad brush to this. And fortunately, it's broad enough that I don't think we need to counsel people now, well, you better not do this because it's really not clear. It is now very clear what they can and what they can't do and to who they will apply to. And Ray will get into that a little bit more. Ray will get into the exceptions, if you want to call them that. I guess that's the best way to put it, a little later on. But the other thing, I don't want to dwell on it right now, but as you indicated before, there's kind of a difference of opinion on this. And I don't know we need to spend too much time on it, but there's a case pending in, I believe it's the Northern District of Texas, and that's where like social legislation goes to die. And I have a feeling the judges have a very pro-business philosophy, as they tend to be, and I'm not going to get into politics, but on the conservative side. And as you go up the ladder, the Fifth Circuit Court of Appeals has jurisdiction over cases in Texas, and they almost make the district court look good. So what I'm trying to say, and I don't think we're going to go crazy going into it today, that the prognosis for what will happen to the rule as it goes through the Texas courts and the appellate courts, which have jurisdiction over Texas, is something to really be concerned about to people who think if you think the rule is a good thing, which we do. We won't even get into the Supreme Court at this point. But so the point is, you have to take these challenges very seriously, because if for no other reason than the place in which the challenge is located, it is a real concern as to what will happen to the rule. So that's what I have to say to start, and I'll turn it over to...
And Rich, right before Ray, you get started, I will tell our audience, I think the ambiguity behind non-competes, restrictive covenants, whatever semantics or language you use, the ambiguity has been purposeful, right? Because it's been done to be, have it be arbitered in a court of law. And to your point, I mean, we looked at the Supreme Court. There is the current lawsuits are challenging a U.S. non-compete ban that spotlights an 89-year-old Supreme Court precedent. So this is going to be an uphill battle, to argue, but that's what we're here for. We're here to get some answers, and I can't wait to hear from Ray, who seems to, be enjoying this ruling. I'll tell you where I stand, gentlemen. I am a fan as an employer. I employ physicians, nurses, social workers, therapists, all the scope. But I am a big believer. I'm a big believer that, again, if I put my business hat on, I think that there are companies that have hidden and have decreased the investment in the culture of their companies and the work satisfaction of their employees by having stringent, restricted covenants, non-competes that have been, quite frankly, abused. And I think that is a new day today where, again, employees will need to invest those monies that they've invested in law firms like yourselves and maybe invest in that into the staff morale of their employees. That's what I'm ready for. But again, I want you guys...
I think you raised a good point about the ambiguity, because if I was drafting one of these, which I would never do, but if I was drafting one of these things, I very well might be tempted to draft something that's ambiguous, knowing that some of the state laws are reasonably strict,
Correct.
Maybe not strict enough, but reasonably strict. So I will get a break, and it would be held that I didn't run afoul of what it was.
Of course.
If I was clear enough, it wouldn't hold up.
Of course.
Anyway,
listen, it's the guidelines that Congress abides by, right? Make it very broad and offer interpretation, and smart guys like yourselves can create case law.
That's a problem. I mean, I don't want to get into a big thing on administrative law today, but basically the Supreme Court seems to be saying that unless it's clear what authority they have, they don't have, the agency said is they may not have the authority. So if you get a broad statute that's not really clear, they would say they don't have the authority. We're not convinced. Or if you get a statute which is really broad, they would say it's too broad. They say what they want when they want, and I'm going to leave it at that.
Ray, what do you think?
So this is a really fascinating debate. I know you asked me to introduce myself and my background. I've been practicing with Zazzali Law for just about 6 years now, so a few less years than Rich, but we are solid labor and employment attorneys. We generally do represent unions, as Rich is saying. Sometimes we do represent employers, and actually recently, relevant to a lot of your audience, I can't say who and I can't describe the parties, but I was involved in representing a healthcare executive in an agreement in an arbitration. And I could see, I think everyone knows, it's no secret that non-competes are very important in the healthcare industry, that so many physicians are laboring under non-competes. And interestingly, if you read this rule and the comment on it, so many of the anecdotes that the FTC took in its rulemaking came from physicians, came from healthcare workers, people who said, I don't feel like I can go somewhere else because of my non-compete with my hospital group or my employer. This effectively prevents me from leaving my job. And that was really what this was about. It was about observing there's been an abuse of non-competes, that whatever the legitimate purpose of them, there had been so many reports about the misuse that you had. Just anecdotes that come to mind, fast food workers, people who wouldn't really be thought to have any kind of confidential knowledge, or, you know, unless it is, the proverbial secret sauce is now the real secret sauce that they're going to go and take across the street to Arby's or Denny's or whatever. But really, you would not suspect them of having any type of competitive knowledge or goodwill that they could transport to their next employer. So you had fast food workers. You had reports about Silicon Valley paying workers to do nothing so that they could keep software engineers and other experts from the competition. And the Biden administration a couple of years ago prompted this initiative that through an executive order, they asked the FTC to study what was the impact of non-competes on the labor market? How is this stifling competition? How does this become really an antitrust issue? And obviously, as is so often the case when it comes to these economic debates, you can cite studies for and against, and you could have an economic debate about it. But there is an argument that this is suppressing wages, which is what the FTC found, that it's worsening work conditions. To begin with, courts were always somewhat hostile to non-competes, even without having an FTC rule. They always implied some type of reasonable restriction into an agreement if it didn't have one, a geographic restriction, a time limit. So it is true, you could draft this agreement with a completely unlimited and vague scope in terms of the geography and the time and what is restricted, but eventually one would expect a court to read a limitation into it, because there is a hostility, I think, to this idea that you don't have the freedom to quit and then go somewhere else and go work for another party, right? I mean, at its most extreme, it starts to resemble servitude or something, or whatever you want to call it. It is a really fascinating issue, and we're ready for all your questions. Anything you want?
Yeah, I'll give you. I love what you guys have said, and I'll give you my take on this again, because I have been a person who's been on both sides, right? So right now in our company, we are a multi-specialty medical practice that is national, and we have a lot of those trade secrets and intellectual property, and we do need to protect our interest and by having non-competes. But I've always been a student of the philosophy, gentlemen, that if you have a strong culture and you take care of your people, that becomes your strongest non-compete, your strongest restricted covenant. And I always say to people, I will take my culture and put it up against anyone, because no one will leave me when you take care of people. I've also been in a position where a former employer has upheld a non-compete, has threatened a non-compete. And I want to get into the non-competes. And I want you guys to answer. Let's again, I don't want to assume the knowledge base of our listeners, right? I want you guys to explain what exactly are non-compete agreements and how they function in the workplace. Let's start there, because what I want to do is I want to create a situation for the listeners of how non-competes, to your point, Ray, have been abused. Because I do think that conceptually, non-competes, if you look at them conceptually in a silo, in a vacuum, they actually make sense. A company has worked really hard. They've invested really hard in Tommy, Larry, and Sammy. And in 3 years, Tommy, Larry, and Sammy want to take the business from them. But what we don't know about Tommy, Larry, and Larry is that the company has decreased their culture. The company has treated that person like crap, and that person has only chosen to leave and probably has taken a pay cut to go somewhere else, because that environment, that toxic culture, has almost depleted their health. So there's so much dynamics that go into people wanting to leave post-employment, and the considerations are sometimes not commensurate to what the other companies do. So my point is, let's explain to the audience what a non-compete is, how it affects the workplace, and I want to talk about how it's been taken advantage of, in the last few years, decades.
It's a great question, and unfortunately, as is so often the case for lawyers, it will not give you a very explicit definition, and I'll point out that it's subject to debate, but it's not a completely wishy-washy way of answering it, because now on its face, in the most obvious form, a non-compete would say, you can't take something like this. You can't take a substantially related position for X number of years in this geographic area, or you shall not do this type of work in this region. However, it's worth pointing out that the FTC has defined non-compete as anything that has the effect. Essentially, I'm paraphrasing, anything that has the effect of preventing you from going and leaving your job and taking a position in with another employer, practicing your trade or your skill. And that could extend potentially to something that on its face describes itself as a trade secret agreement. It could extend potentially to something that is described as a non-disclosure agreement, a confidentiality agreement. So it could actually apply to a lot of agreements.
If you want to simplify it, I'm sure below us or our audience, you could say you can't do this job. You can't work as this engineer or chemist or whatever it is. You can't do it in this area, meaning you can't do it within 20 or 30 miles, maybe more, and you can't do it for 2 years. That would be in a very simplest form. Now, one question I have, and I don't want to get ahead of us, basically what the FTC is trying to do is balance the rights of, I think you said Sammy, right? Balance the right of Sammy and the company Sammy worked for. And I think what they have decided, considering all the economic aspects of this, is a non-compete, the balance is 100% in Sammy's favor. However, when it comes to trade secrets, secret sauce, etc., the balance is in the company's favor. I would think in most healthcare settings, in most hospital settings, there's not a strong argument that there's a lot of confidential information or trade secrets that somebody's going to take with them. Not in terms of developing medical devices, but if I'm a nurse or even a doctor or a medical technologist, I'm not sure the hospital has any secrets that they have to worry about me taking away. So I think, and I'm talking somewhat off the top of my head here, but from my knowledge of what these professions do, there's not a real strong argument that there's going to be trade secrets or things of that nature that they have to be protected against. And by the way, the FTC, I think, is aware of that, because they say you can call it trade secrets, you can call it non-disclosure, but if what it really is a non-compete, we're going to classify it like a non-compete. But I think what I said just a minute or two ago is probably the simplest possible definition of what these are. And it's not a restrictive covenant. That's a whole nother thing, has to do with land, and usually not for a good motive, but forget about the term restrictive covenant.
Beautiful. So I appreciate that. So we'll use non-competes just for the purpose of this conversation. But here's one thing that I want to make sure that we don't, again, in the spirit of transparency and not to be further ambiguous for our audience, I think I need us to get real with the audience, because I don't think, and Rich, you kind of just you made me think of this. So the non-compete, right, in its simplest form is just, you're not gonna go anywhere else and do what Ray mentioned to be the secret sauce, right? Got it. And to your point, in healthcare, there's no really a secret sauce, right? Taking care of patients is taking care of patients. But gentlemen, let's be honest here. Non-competes are not used in the way that they're used. And I'm going to give you guys, I want you guys to touch one point that has always bothered me. And that is that consideration that is given when a non-compete is signed, right? There are times where the consideration is that, if the person for this amount of time will get X, but usually a non-compete is signed as the sole consideration being employment. So basically, an employee has no option, right? So that's one thing that I want you guys to comment on what is the appropriate consideration that a non-compete should have, right? But the other thing that I want to know from you guys, the experts.
I think Ray's going to answer, but let me just say, we're going to find out. We're kind of in a laboratory here, because let's see what happens to salaries in positions that were subject to non-compete before, and what's going to happen to those salaries now that there are no non-competes. And I have a feeling there's not going to be a huge difference.
Listen, in healthcare, there's not going to be a huge difference, because reimbursement is not, unless the federal government and insurance payers are going to give us a raise, which that's not happening, the salaries are not going to change. What's going to happen is there's going to be more competition. There's going to be more competition, and companies who can't compete because they can protect their interest by handcuffing people either with the golden handcuffs or the golden parachute. We again, it's going to be very difficult. I love it, guys. I think this is going to be an incredible change for the industry in a good way. But here's what I was getting to, Rich. Usually, okay, a company knows that perhaps the non-compete, as it is written in form, may be too restrictive, that if it goes before a court of law, it will get nullified, it would get absolved, and it'll go away. But just presenting that lawsuit, just serving that individual with a lawsuit, having that individual have to invest in protecting themselves with a lawyer, they have accomplished their goal. Even if it never goes to court, even if they get a ruling 12, 18, 20 months later against them, the person's not going to get reimbursed the money they spent on an attorney. The person's not going to get reimbursed the stress, the pain and suffering, not being able to feed their families at a time where socioeconomically the cost of doing business in life has gone through the roof. So I think that's the area where I want you guys to focus with the audience, because non-competes really are going to preclude employers from using a bullying tactic, which is, let me serve this person, even if we don't pursue the case. Just sending them that bomb and that initial even threat of a lawsuit is strong enough. What do you guys think about that?
These are all really great points, and I think your two questions really goes to the unfairness and the inequality between the employer and the employee, and the realities which are well known and which are exactly what the FTC was focused on when it made this rule. And it's looking at the fact that these are invoked for their interorum effect, which is a fancy Latin word for saying we're going to scare you into complying. And that's what happens. And we all know that. And the employer knows that. And the lawyers who represent employees like us know that. And you know what? It's not always in somebody's interest to challenge a non-compete clause, because you're absolutely right that it's not worth it for your right to go work at Denny's across the street that you would spend $100,000 litigating it in an arbitration. And nobody in their right mind would do that, even if you actually have the rights to do it. So that is exactly why the FTC has passed this rule. It's not entirely clear how it's going to be enforced, because there isn't exactly, a private right to go and sue your employer right now, not one that we're aware of, for trying to make you sign a non-compete. And it's not clear if the non-compete rule will be upheld. There's a strong chance that there's going to be an injunction barring this FTC rule at some point in the future. But that is what they're looking at. They're looking at how unfair this is. And as a matter of fact, there's only one group of employees that the FTC said, although it's unfair for them too, it's hard to believe, but for executives, for the people in the C-suite, they are still being forced into signing these agreements. But at least they said, okay, well, we recognize they've probably, and I've seen that with executives that I've represented in the healthcare setting, that they have negotiated the golden handcuffs you were referring to. They got extra consideration. They got extra benefits for their non-compete.
But I would say in the average case, to me, that consideration is illusory. I really don't think that employers do it as extra consideration for somebody staying, or that the person gets extra consideration. I think they just do it because they can and they don't want to lose that person. But I don't think it affects the salary or the benefits that the employee gets. That's just off the cuff. I don't know if, pardon?
100%. You're absolutely right. And again, when it's easy to have an attorney draft a threatening letter, even with the attempt to say, hey, I'm going to sue you, it's enough, guys. It's enough to curb the behavior post-employment of that individual. I've been in those shoes. Where I have a doctoral degree in what I do. I went to school, spent a lot of money to become very highly educated and become an expert in my field. And I was told, right, that I couldn't practice my work because of a non-compete. And I think, again, to your point, Ray, that unfairness is that to put that to rest is long overdue. So again, the ruling hasn't been finalized, and as to your point, it's an uphill battle to make it stick potentially. However, I'll give you guys a little bit of empirical information that I just got this week. Actually, I just got this morning, and perhaps you guys, at your comfort level, can give our audience listeners, maybe if you guys have heard this. So there were two cases of friends of mine that they were being, for the last year and a half, they're being chastised by their previous employer and threatened on a non-compete. These two individuals have spent a tremendous amount of money in attorneys. The company even went as far as to say, we will pay you 12, 18 months of severance if you don't work. And 2 days after the FTC ruling, the company came to these employees and said, actually, just kidding. We're going to drop everything, but we're not going to offer you money, and we're going to go away. Do you think, obviously coincidence, I don't think it's the fact. I think they're looking at, whoa, perhaps we shouldn't chase this. Are you guys seeing a change of heart from companies that were heavily trying to litigate and uphold these non-competes based on the FTC ruling right now, and they kind of just want to go away and prepare for it to potentially stick? Where do you guys sit at? What are you guys hearing?
Well, here's what I'll say. And, Rich, you can add anything you want about this. And the rule has been out too soon for it really to have trickled down to us to be seeing disputes over it yet, because it was just issued and it's not supposed to go into effect until August, I believe. But having seen other similar pro-worker changes, one big one in recent years was banning non-disparagement and non-disclosure agreements for discrimination and sexual harassment victims. And I had seen how even despite a clear statute saying if you have a claim about sexual harassment, you can't be made to sign an agreement that keeps you from not speaking about that, I still saw employers putting that provision in agreements, employers relying on really fanciful pretend distinctions to try to say, well, this agreement doesn't violate the law, but really it had the same effect. And so I do think that even after this rule is rolled out, particularly, I don't believe it has a private cause of action that would really give it teeth. It's really going to be relying on FTC enforcement. I do have a strong feeling that many employers will continue to try to use non-competes. Of course, I don't have a crystal ball, but that's my guess.
Well, I can tell you along the lines of what Ray was saying, even before the law against discrimination cases that said you can't prevent people from talking about this stuff, the settlements would be by law public documents, at least if a public agency was involved, and employers would just say, the heck with it. They try to do it all the time, and if somebody asks for it, we'll show them, but we're going to consider it private unless we're forced. So that could well happen. Except if I want to be an optimist, this has gotten a lot of publicity. And that may have some impact on what employers want to do. I also wonder, not to really change the subject away from it, if the real concern is that Sammy will go and work someplace else and I spend all this money training him, or the real concern is Sammy knows our secrets, he has our customers, and we're going to lose a chunk of our business because Sammy left. I just wonder really if the non-compete, if it's really aimed more at Sammy having some of our business, some of our customers, etc.
Listen, I think, Rich, the answer to your question is a resounding yes, right? I think that's common sense. As an employer, you don't want to have your trade secrets go over to the competitor, right? But that's, to me, 5%. As someone who operates a healthcare business, I also can't prevent Sammy to go somewhere else and share my trade secrets if my work culture is not appropriate, if I'm not taking care of them, right? The saying, the old adage is, a good boss is more important than a good doctor, because a good boss has more effect on your health than your doctor will ever have, right? A good boss, or I should say a bad boss, will have more of an effect on your family, your lifestyle, your everything, as opposed to the good doctor. So I think there's more that this law will do than to protect someone for having their secrets stolen. It will protect the employee from really just being a more productive employee and probably have less dependence on the government. And we're living in an age where mental health and all those things are absolutely terrible. And again, workplaces, I think, that have toxic work cultures.
Well,
really,
to their credit, not to put a plug in for the FTC, but they realize the distinction between the private information or the secret sauce and saying you can't go work somewhere else. And so they will address, if you're going to have, you can't work someplace else dressed up as it's secret information and you can't take it with you, they will deal. They're dealing with that.
Question for you two gentlemen: do you guys have non-competes at your law firm?
We do not have any non-compete agreements. It would not be.
Yeah, we made him a partner so we couldn't compete just recently. No, we don't have non-competes.
Why not?
That's true, by the way.
I don't even know. I don't want to get into legal ethics and all. I doubt that you could even do it in a law firm, because anybody can choose. My thinking is, you can fire an attorney, hire an attorney. Anyone can choose their own attorney at any time. So
why shouldn't it be like that everywhere, Rich? Why shouldn't it be like that everywhere?
I think that if you wanted to sit down and come up with a justification for non-competes, and I think there could be some justifications, it might be that it's unfair if somebody has inside knowledge and also relationships, and they have a duty of loyalty to their employer while they're working with them at the common law. And then if they go somewhere else and they take those advantages and they use them to compete with their former employer, you could make the argument that can be potentially unfair. But I mean, of course, in the vast majority of situations, what you really have is nothing like that, I would say. Most people they just need their job, right? And if they want to leave, they want a different job. And I don't think that most employees are nefarious and taking advantage of their employer.
I agree with you. I'm going to give you a scenario. And I want to see what you guys think. So last week, the Department of Labor, actually this was a national statistic, they came out with salaries that are needed to live comfortably. I don't know if you guys saw this list. Maybe you did, maybe you're not. A single adult, what do you guys think a single adult in the United States needs to make to live comfortably?
$50,000 a year.
$70,000.
$94,000 a single adult needs to make to live comfortably. The national average is $94,000. 2 working adults and 2 children. What do you think?
$150,000.
$175,000.
$210,000 for a family of 2 working adults and 2 children. The salary needed to live comfortably is $210,000. So
what does comfortably mean? You're talking middle class or middle class plus a little bit, or
that's in the spirit of ambiguity. That's basically how the report came out. So I'm assuming having a home, again, having the amenities that an average American would have. So to your point, Ray, based on that, I can also make a case that if I'm working for an organization, and let's say I am a social worker, and I make $70,000, and then I have another company that's offering me $95,000 so I can potentially live comfortably, which is what the government is saying I need to live comfortably, and this company's offering it to me, but I am held to abide a non-compete. I can't do this. So in essence, we're keeping people from living a life, and again, in a day and age where people are living paycheck to paycheck and having all these things. Could you make a case that yes, we want to protect the interests of employers, but we really got to protect the interests of Americans?
Well, we're labor attorneys. We represent labor unions. We represent working people. We would be hard-pressed to disagree with any of that, and that's clearly what the spirit of the rule is, which its enforcement is very much in doubt. This is a very serious challenge that's posed in the Fifth Circuit. I would imagine, if I had to predict, it would go to the Supreme Court. And the Supreme Court has signaled in its recent cases that this majority doesn't like agencies overreaching. They've struck down agency rulemaking. This is a rulemaking that the FTC did. They've struck down several of them in the past couple of years.
I don't think it's just that, though. I think it's I think it's just as much what the agency does, because they'll find a way to rationalize. If they don't like the rule, they'll find a way to rationalize, even if it's not an overreach.
I agree.
Fair enough. Right. That's also part of it.
Let's put another caveat into that. Rich is. I like Rich. He thinks like me. Ray's too middle of the road for me. He goes back and forth, but he's a typical attorney. Ray's a typical attorney, but Rich. So I'll tell you this. How about it's an election year? Again, this is a voter swaying topic. Will that have an effect on the final ruling?
Possibly. It depends how steamed up voters are. I think there have been a few decisions where they've just had so much public pressure they had to back down, but they don't back down much. They seem to do what the heck they want. So it depends how big it gets.
So let's play.
It's also worth.
Go ahead, bud.
It's worth noting that the FTC is not the only agency that has signaled they want to go after these agreements. The National Labor Relations Board has a general counsel who's in charge of enforcing labor law under the Act, and she's also signaled that she plans to pursue a ruling to invalidate non-compete agreements. It's not the law yet, but she's made the argument that these are also unlawful under the National Labor Relations Act.
Wow, tell me more about that. Tell me more about that. All right, tell me more about that. So there's another governing body, in addition to the FTC ruling, that is also looking to weigh in and pretty much align themselves with the same recommendation of the FTC. Tell our listeners.
Well, whether the general counsel is willing, we don't know whether do we know whether the board itself.
The board has not ruled.
Board has not ruled in, but the general counsel has taken that position.
But we should explain this. So the National Labor Relations Board, created under the New Deal when you had the Wagner Act and you had unionization in the 1930s, and it protects the right to organize, but it's not just that they represent unionized workers. They also represent all private workers. Not everyone knows that. And they are both their own prosecutor and their own judge. Of course, the two functions are separate. So you have who's called the general counsel. The current general counsel is Jennifer Abruzzo, and she is the prosecutor of the National Labor Relations Board. And she has signaled that the policy, she wrote a memorandum about the aspirational policy that she thinks under the National Labor Relations Act, which is supposed to protect employees' right to organize, their right to complain about the terms and conditions of employment, to get together with the next guy and say, hey, what's with this place? We should get together and form a union, or why don't we go and say something to management? Well, if you have a non-compete, the general counsel has said, people are afraid to do that. You're afraid for your job. If you don't feel like you can go and quit your job and walk across the street and go work for the Denny's over there because you work for Burger King and you have a non-compete, then you probably are going to be too fearful to exercise your rights.
I think also, because maybe people don't realize this, I'm almost sure, Ray can back me up here, that the National Labor Relations Act protects not just union activity, but concerted activity, which means that if 7 employees went to the boss and said, you can't do this, this isn't fair, blah, 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 and the boss retaliates, I believe that would be protected under the National Labor Relations Act, even though they're not a union.
So,
If it's concerted.
so you just teed up my next question, Rich. Rich is looking at my notes, I think. So you just teed up my next one. So what is the possibility? And again, maybe you guys deal with a union, which is very similar to what I'm going to say. But what is the possibility that this sticks, right? That this catches enough, publicity? It's being sensationalized to the max. I think the next 4 months, I'm not going to be the only one doing this. I think it's going to be a tremendous push. But what do you can this potentially go into something that could be class action?
You say class action?
Well, a class action is its own term, yeah. But I think what you mean is, what's the chance that this becomes a mass movement, that this catches on, that people want to start challenging? Well, I think anything is possible, isn't it? And you really never know what could happen.
I think you would have to get a sexier or more colorful name for it, because when you say Federal Trade Commission, you say non-competes, I don't think it would get people don't know what they are, they get their blood boiling. So you kind of need a nice way of putting it, I think.
So I guess the answer I'm looking for, yes or no, can this potentially, if it's sexy as, Baywatch, Pamela Anderson, and it catches wind, can this potentially be a class action?
Well, no, I don't think so, because a class action would mean somebody files a person and many join file a lawsuit to do something. If there's no private cause of action, I think our marbles or our eggs would be with the FCTC.
So what if I file a lawsuit and have 10 other people?
As we know of it right now, we don't believe there's really a cause of action, meaning there isn't a private right to sue to enforce this rule. As to whether there's going to be some, and this is all completely new. We don't know how this works yet. We don't really know until the rubber hits the road.
What I'm asking, I need you guys, listen, we're speculating here a little bit. So speculate with me. Let's say August 1st comes, this, for whatever reason, the people who are going to rule have a change. They say, you know what? This is the way we voted traditionally. We're going to vote to uphold this because it makes sense, blah, 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 blah. And then this sticks. So now I, as an employee that has been previously, abused by a non-compete, also make a big campaign and get other people to join me. And can I file a class action lawsuit against a predator employer?
I don't think so, but one thing that could be done is that people could, or groups could join in and support the Justice Department, who, defend the FTC. I think it's the Justice Department will do it as amicus and become parties to the case where they can present, what their positions are. Another possibility, and now I'm just kind of shooting from the hip, is some of the states that have initiative of referendum, they could pass their own provisions barring non-competes.
Understood.
And if the right explanation could be very popular. I think you hit on something earlier that I think is a real good point, though. Saying that I can't get a job someplace else, that doesn't seem consistent with capitalism, whether pure capitalism or controlled capitalism. On the other hand, saying I can work for you and then I can take all your secrets and make my own business, that doesn't sound right either. So I think they've really struck the right balance. But I think we have to think of ways to really make it very simple and very catchy, so people understand it.
Last thing for both of you. I want you guys to, let's play again devil's advocate. And Ray, I want to hear from you first. What should employers and employees do right now, whether this sticks or not? How can both parties be preparing for the next months ahead?
I think that employers are going to look for the exceptions, and they're going to say that if you have a trade secret agreement, if you have a non-disclosure agreement, it's perfectly valid non-disclosure agreement, perfectly valid trade secret agreement, and that's what they're going to use. And they're going to find other ways to restrict their employees, and they're not going to call it a non-compete, assuming this law holds up. And there are many exceptions, and one that's very important in the healthcare industry is that, at least on its face, the FTC rule would not apply to nonprofits. And we all know that there are many hospitals and healthcare systems that are organized as nonprofits. And at least on its face, this is not something that is going to apply to nonprofits. The only caveat being the FTC can sometimes determine a nonprofit is really a for-profit, despite what they call themselves. But generally speaking, it will not apply to nonprofits, so there will be exceptions, and employers will look for a way around it, and they will find some ways.
Were you saying what they should do what we should do jointly, employers and employees together?
Not jointly. So that's because, again, we're speaking to both audiences. So that means our listeners can be employers and our audience can be employees.
Well,
so what should be?
I think
that's
I
how do we
think
should
you
we
hit the
prepare?
nail on the head for the employer. The employer should want to create the atmosphere where I'm going to stay, where I want to stay. If I can make a baseball analogy, Billy Martin's a great manager, if you remember him, for 2 months. And then people get tired of him driving a whip on them and they don't respond. And the employer should realize he should make it attractive, or she should make it attractive enough that they want to stay. And people do leave for all kinds of reasons, but at least hopefully they won't leave if you make it attractive enough for them. And the employee should recognize the employer's side of this coin, which is, yeah, I don't want to leave, but if I leave, I'm not taking your secrets with me. And I think that's, if people understand what the fair balance is, and it's not that hard to get to, I think that's what they should be doing right now.
I'll never understand, Rich. I agree with everything you just said. I'll never understand why sometimes employees are short-sighted. The whole, and let's talk about healthcare right now, but I think this might expand to everything. There's a beneficence aspect about humanity. Most human beings want to do the right thing when the right thing is done by them. Let's just be honest, right? I don't have to be an attorney to understand that if you take good care of me and I decide to leave, I'm probably going to take good care of you. But I also understand that if you don't take good care of me consistently, and then I go somewhere else and I liberate myself from you, that I'm probably going to bury you, right? Because there's that retribution that exists. So I think my advice for employers is take care of your staff. And my advice for employees is don't think of retribution. If you're not happy, look for other places and maybe have conversations proactively with your employer to just say, hey, listen, just like every romantic, professional relationship, communication is best. And I've always said, when you earn my loyalty in my heart, I'll give you both, but only if I have your trust. And I think we need to be able to gain more trust. And I think right now, the worker and their employer, our trust is just very, very, very far apart. And I think more than it's ever been. Do you guys notice that right now?
Yeah, and it behooves everybody not to burn any bridges.
I agree.
You just never know. You never know.
Gentlemen, where can my audience find your services? I want to make sure that our audience, if they have any questions, if they want to, again, retain you guys, that the audience is able to understand where to find you guys.
Well, we're online. We have a website.
What is that website?
Zazzali PC is the firm.
This is Zazzali PC, and we're in Newark, and of course there's the capital, so we're also in Trenton.
So what we're going to do is we're going to link your website on our when this goes live, and I want to make sure that any people that go to you, I get a referral bonus to make sure that we sign a non-compete on that. Listen, guys, it's been a pleasure to have you on the show. This morning, I didn't even tell you guys this ahead of time, we had 2 HR, human resource experts on this call. And I want to praise you guys for your answers because it was exactly how this morning kind of went, meaning that, and I was busting your chops right earlier, but you're absolutely right. I think right now we're in a position where we have to be conduits of information, but we can be saying this is what's going to happen because I think that's irresponsible as well. So you guys were amazing guests. Any last words that you guys want to say to our audience, a call to action, anything you guys want to say? Again,
let me think for just a minute, but I just want to thank you because I think you did a great job of moving it along and getting out giving your heart and getting out what we needed from us. It's good, really good. Let me think about it. What do you think? Anything?
Well, you have to really look at what's happening these days and be heartened that there are these efforts to recognize what the economic realities are and to give workers a bigger voice and hopefully to change what many people feel is an unequal situation And you can really credit that to the Biden administration. And I'm not even saying that as a political person, but this Democrat, Republican, whatever, Biden has been one of the most pro-worker, pro-union presidents in a long time. And we don't know what's going to happen. It may be that these efforts will all flop. We saw what happened in another realm, say with student loan forgiveness, and that was not successful. And the courts are going to have to deal with this. And it's a very aggressive, very loud and bold move, and it may not be upheld. But I think what you're saying maybe is, hey, this will inspire people. This will spread the awareness. Who knows where this is all going? Because I think there's a change in people's thinking and consciousness about what's happening in the workplace.
Yeah, I think to just follow up on what Ray said, I forget one of the commentators or one of the talking heads, and I don't remember who it was, said, this is something we're going to have to do ourselves. And people have to realize that. They're going to have to come out. They're going to have to work for this stuff. It would help to have a nice label on it that would be easy for people to follow, but it's not going to happen magically. People have to, they have to vote for what is in their interest instead of noise. They have to go out and do these things and accomplish them themselves because nobody's going to do it. They might take it away, let alone not do it.
But, gentlemen, I'll tell you one thing, and again, just healthcare-wise, we have the worst healthcare outcomes of any developed nation. We have the most expensive healthcare system. Not even close, right? We spend 90% of a $4 trillion budget in the last 12 months of life. Again, I don't want to get into a platform of how our healthcare system is just terrible. However, what I'll get into is that this particular FTC ruling will go a long way at improving healthcare. I've always said to people, the last person who graduates law school is called what? A lawyer. And the last doctor who graduates medical school is also called a doctor. And I think that in a competitive spirit, we got to make sure that we really go and fix things and hopefully leave them better than we entered it. We have two very.
I know of young doctors who worked at, I think it was Duke. I'm not positive. I'm pretty sure. You get 10 minutes a patient.
5 to 7 minutes is the average. 5 to 7 minutes.
I can tell you, I've had a few situations where I've gone to the doctor recently and, I've told the doctor and, I represent unions and maybe it was at one of these emergency care places or the in-between places. And they've said, hey, you should come and organize our workplace. And then it sort of raises your eyebrow a little bit to think that now and you hear about doctors unionizing because it's true. There's something, not to completely disparage it, but there's definitely some fundamental problem with the healthcare system. I think people feel that way now.
We have two very noble missions, guys, and you heard my opening mission statement, and I close all the podcasts with that and open with them. But we have two very noble missions, and I think this non-compete ruling will help me get closer to that. Number one, we are staunch supporters and believers that the best days of healthcare are actually ahead of us, not behind us. And I'm also a very, very staunch believer, Rich and Ray, that I want to leave healthcare better than I entered it. And I've done very well in this business. Very well in this business. But trust me when I tell you.
Well, you did a really...
I said, trust me when I tell you. When I leave, I want to make sure that I improved it. And there's nothing that I can improve healthcare more if I change the demographic, the identity of the human capital that deploys and serves our patients. And that's the healthcare provider. Go ahead, Rich.
Well, if you do as good as you did moving the podcast, you'll do fantastic.
Oh, I appreciate it.
No, seriously, it made it real easy for us. And I do have to give a shout out to Christina, wherever she's hiding, for helping.
She's right next to me. Listen, it was a pleasure. I enjoyed having you guys. Hopefully this is, one of many to have you guys, because I think this is going to catch legs and catch wind. And why not have
we enjoyed it.
You guys back?
I know I enjoyed it. I think Ray enjoyed it too. So we enjoyed it.
Ray, did you enjoy it? Okay, he enjoyed it.
Yes, I did.
He enjoyed it. And we are changing the habits of yesterday by creating the new healthcare reality of tomorrow. Thank you, gentlemen. It was a pleasure.